There are two statistics I'd like to share with you, which I think indicate the problems that we have in the Cayman Islands. The first one is that when it was last measured, 73% of prisoners returned to prison having reoffended, which is a high percentage when you compare it with the rest of the world. For the rest of the Caribbean, the figure, for example, is 60%. So we're far higher than our Caribbean neighbours. The other statistic, which I think is relevant, that we want to address, is the fact that compared to the average prison population internationally, we are nearly double the amount for 100,000 population. The average internationally is 168 prisoners per 100,000 population. If we do the maths and compared to Cayman statistics, we are nearly double that figure at 346 per 100,000 population. So these are the two statistics which we want to improve on as a result of the conditional release law. So the two things we want to impact is the reoffending rate and also the prison population, the size of the prison population. Okay, before I talk about the differences, let me just say that the National Security Council back in 2011 developed a strategy to reduce crime. And there were a number of strategies involved in that. But the one that this conditional release law will focus on is reducing reoffending. The other strategies were early intervention, enforcement, and also to look at ways of actually reducing the level of crime in the Cayman Islands. So this is the Deputy Governor's Office response with the government's backing to try and reduce reoffending. The differences between the old regime and the new regime. The old regime meant that you could walk out of prison after 2/3 of your sentence without being rehabilitated and without and still being a risk to yourself or to society. The new regime will focus on rehabilitation and will focus on risk. The old regime didn't have a law to support it. It was part of the prisons law. This is a new law and regulations that will provide a much more robust regime. The other difference is the fact that at present time, well, before this new law came into effect, the governor made all the decisions with regards to parole. She made the decisions on whether to release or not to release, whether to recall or not to recall. The new law sets up a new board, a conditional release board, which is totally independent of government, and they will make the decisions and not the governor. But the major difference between the two regimes is that the new regime requires every prisoner that is serving more than a year in prison will have to serve 60% of their sentence. That's different to the regime that existed before. Prisoners, depending on their offence, could be eligible for parole after 1/3 of their sentence or 50% of their sentence. So the new regime means that they will have to stay in prison longer. So that means that early date of release scheme is being scrapped, because that meant that, as I said earlier, that after 2/3 of their sentence, a person could walk out of prison regardless of the risk to society. That's no longer the case. Every prisoner that comes out on conditional release will be on a license, and that license will last to the end of their sentence. So if someone is sentenced to 10 years in prison, they will be eligible for conditional release after 6 years. And then they will then be under license for a further 4 years. So the prisoner will be supported in the community for 4 years, where he will be having to be under the monitoring of a probation officer. The law was passed in November of 2014, and then we developed regulations. So the law and regulations will actually have come into force. They came into force on the 15th of February. But let me say, to explain, that this is not retrospective. So the prisoners that were sentenced before the 15th of February, it will not apply to, apart from those that have not been given a tariff, and I'll explain that a little later. So if you were sentenced prior to the date of the implementation of this law, the old sentencing regime and parole will apply. But the law applies to all prisoners that are sentenced after that date that have been given a sentence of more than 12 months. Now, it also applies to existing prisoners that have not been given a tariff. What that means is they are prisoners serving a life sentence without a term or tariff. When the law comes into being, and I'll talk about that later, how we're going to be dealing with the 15 life prisoners, life sentence prisoners that are currently in Northwood. The new board that has been appointed, there are 9 members of the new board. They have been selected. There was an open interview process. The governor has appointed 9 new members. They consist of persons that have experience in the criminal justice system, lawyers, a counsellor, a psychologist, and an ex-magistrate. So the new board have been trained. We invited 2 specialists from the UK to train them, a parole board member in the UK and also a lawyer who specialises in parole. They came over and were funded by the governor's office. They came over and trained the new board. And we've also trained locally all the professionals that will be contributing to the board decision. The staff of DCR, the police, the counsellors, the prison officers have all gone through local training. What will the board take into account? Well, the advice they will get will be coming from professional people. So the board will have a number of psychological or psychiatric assessments done on the potential prisoner to be released to assess their risk of reoffending. If the prisoner is going to be released, then the board will decide the conditions of a license. Now, the conditions of the license will vary according to the risk factors that are apparent. So there will be certain conditions that are applied to all prisoners on release. Those include that they have to live in the premises that is agreed by their supervising officer. They have to either be engaged in gainful employment or registered with the NWDA and looking for work, or engaged in any community service work. All prisoners will not be allowed to travel outside the Cayman Islands while they're on conditional release, unless there are extreme circumstances involved. If they want to travel between the islands, then they are allowed to do that, but they have to have permission of their probation officer, and the probation officer in the Sister Islands would then take over the monitoring of that person. So that's the sort of basic license that will be for all prisoners that are being released. But then there are some license conditions which are dependent on the prisoner's particular risk factors and their conditions. So there may be a curfew, that the person cannot be out after 10 o'clock at night, so it has to be in that residence between 10 and 6. There may be certain areas that the prison may not be allowed into, certain persons they're not allowed to mix with. if there is certain drug or alcohol problems, it may be that they will put a restriction on the visit to licensed liquor premises. But we want to make sure that the conditions are proportionate to the individual prisoner, because we want that person to be able to integrate into society. So if we put a ban, say, on attending a liquor premise, a bar, that may interfere with their integration, in terms of that most restaurants on the island have a bar. And if they want to go to have celebrate for a birthday or an anniversary at a restaurant, we don't want the license to necessarily interfere with that integration back into family life. There would be supervision in terms of drug testing, random drug testing will be carried out, alcohol testing, and the license condition may also specify certain programs that they have to attend during their time on conditional release. So under the new regime, every prisoner entering prison will have a sentence plan designed to map their progress through their period of incarceration and their period in the community. And one of the elements that the new Conditional Release Board will take into account: has the prisoner complied to their sentence plan? Have they participated in education programs while in prison? Have they gone through specific interventions like anger management programs or sex offender courses? So those are the things which we set out in the sentence plan. And that plan will continue when they are actually out in the community. So there'll be a great support for the prisoners when they're in the society, because we don't want to see them return to prison. So the support element, not just from the probation officer, but by employers, by family, we need to make sure that the prisoner is supported so that they hopefully will not return to prison. The new law will allow prisoners that have been sentenced to life, within 24 months of the law coming into effect, they are able to apply to the Grand Court for their case to be reviewed and a tariff given. What that means is that the Grand Court judge will review all the papers. They're not retrying them. They're just saying what sentence they should have, taking into account the circumstances of their crime, of the murder. So the Grand Court will then decide on a term of imprisonment. Now, I just want to clear up some misapprehension of this. What it means is that the new sentence will be a minimum sentence. So the law specifies that for murder, the minimum sentence, the starting point will be 30 years. But the judge of the Grand Court will have the discretion and the flexibility to vary that 30 years. That 30 years is when they will be available or can apply for conditional release. It doesn't mean they're going to be let out after 30 years. They're going to have to apply for conditional release at the 30-year point. But as I said, the judge can vary those, that 30-year period. And depending on aggravating circumstances or extenuating circumstances. So, for example, aggravating circumstances, the law actually the regulations actually set out some guidelines for the judge to look at. So, for example, some of the aggravating circumstances, and I'll read from the regulations. The aggravating circumstances that may be relevant to the offence of the murder include a significant degree of planning or premeditation, the fact that the victim was particularly vulnerable because of age or disability, the mental or physical suffering inflicted on the victim before death, the abuse of a position of trust, the use of duress or threats against another person to facilitate the commission of the offence, the fact that the victim was providing a public service or performing a public duty, so a policeman or a prison officer, concealment, destruction or dismemberment of the body, previous convictions, abduction and sexual or sadistic conduct. So these may be taken into account by the judge to increase the sentence from 30 to 40 or 50 years. Now, on the other side of the coin, the extenuating circumstances are an intention to cause serious bodily harm rather than to kill, the lack of premeditation, the fact that the offender suffered from a mental disorder, which lowered the offender's degree of culpability, the fact that the offender was provoked, maybe by prolonged stress, the fact that the offender acted to an extent in self-defense or in fear of violence, the belief by the offender that the murder was an act of mercy, and the age of the offender. So those circumstances the judge may take into account when he wants to reduce from 30 to say 25 or 20 years. So these are the sentencing guidelines that are put into the regulations. Once the tariff has been set, then the life prisoner will be eligible for parole at that tariff. And it means then that if the person is released, the prisoner will be on a license for the rest of their natural life. Okay, so those license conditions may change over a period of time, but they will be on a license for the rest of their natural life. The victims of, or the victim's family of the crime are involved in the process at the moment, but what the law and regulations do is to actually formalize that. So the victim has the right to participate in the process, doesn't have to, it's a voluntary a process for the victim if he or she chooses to be part of it. So what happened is once the prisoner applies for parole, the Department of Community Rehabilitation would seek out the victim or the victim's family and ask them if they want to make any representations to the board whether the prisoner should be released or not released. So at that point, the victim is asked if they want to make a written statement to put before the board, or they can request to actually speak to the board at the hearing, at the conditional release hearing. The victim also is consulted on every stage in the process. So if the prisoner is to be released on conditional release, then the victim will be told the date of release, will be told what the conditions of the license are. If there's a decision to recall the prisoner because of a license condition not being met, they will be told that. So the victim is going to be very much of the whole process from the very beginning, before the board meets, and afterwards. So the victim is much more involved in the process than previously. The human rights, or the Bill of Rights, implications are twofold. The first one is that it affects the rights and freedoms of prisoners, but it also specifies in the Bill of Rights the responsibilities of public officers in the process. So let me deal briefly with the first, the rights and freedoms of prisoners. Of course, there are maybe 4 to 5 rights that are going to be affected by the conditional release process. One, which is Section 5 of our Bill of Rights, which is personal liberty. Section 9, family and private life. Section 13, which is freedom of movement. Section 7, a fair trial. And Section 16, non-discrimination. So what that means is that we have to make sure that there is a fair process, and it's an independent process, and it's a process which is done in a timely manner. So that's the fair trial part of it. Freedom of movement. We cannot artificially restrict the freedom of movement unless there are good reasons to do so. Family and private life is one that will be affected. So if the conditions of the license affect the person's family and private life, then there has to be a good reason to do that. As I mentioned about the restaurant visit, if we say to all prisoners you can't go near a liquor license premises and they cannot then go and enjoy family celebrations, that will affect their private and family life. So we have to make sure that the license conditions are actually tailored to the particular prisoner, and they're not proportionate, that they are fair, and what we need to understand is that all the decisions made by public officers have to be lawful, so they have to comply to our law and regulations, but they have to be rational and have to be proportionate, and we want to make sure that all our policies and procedures are procedurally fair. Because we make a decision as a public officer under Section 24 of the Bill of Rights. That public officer has to give reasons. So if the decision that a public officer makes is going to affect that person detrimentally, then decisions have to be, reasons for those decisions have to be given. So it's important that we don't have any processes and procedures that are incompatible with our Bill of Rights. The conditional release law and regulations are posted on the Deputy Governor's website for people that are interested in seeing the detail contained in the law and regulations. The government believe that we will be able to reduce our recidivism rate because of this new law, and in time we will be able to reduce our prison population. But it will take time. But what's more important than all of that, I think, is that we're going to make sure that anybody that's released in society under license is not a risk to the public and is on the course to be rehabilitated so that they can take their normal course of life in family, in the community, and in their workplace. So we're confident that these statistics I talked about in terms of the prison population and reoffending will reduce, but it's not going to be an overnight issue. It's going to you will see the results of this gradually over the next 3 to 4 to 5 years.